Joining me now, Kermit Roosevelt, University of Pennsylvania law professor and author of The Nation That Never Was, Reconstructing America's Story. Chuck Rosenberg is back with me, and here with me in studio, Harry Litman, former U.S. attorney and host of the Talking Feds podcast. So, Harry, you clerked for Justices Kennedy and Marshall. You know a little bit about the Supreme Court, and I want to dig into some of the things that the folks who were watching the arguments may have heard but need a little more context for. And I want to start with where your sense is of where the justices may land on the issue today, what it means to be subject to the jurisdiction of the United States.
Okay, so that clause, as well as the case, there's a small way of looking at it and a grand way of looking at it. The small way, and the way they've always said they look at it, I think is straightforward. Subject to the jurisdiction means you're here, you can get a driver's license, you can be sued, you're part of the whole social contract. That means, and it's an overall democratic kind of big proclamation, you're a citizen. The efforts, and I think Ms. Wong got it right, the efforts to change that meaning had to do with the consequences. Like, oh, wouldn't this be a flood of people coming in, wanting to have their children here? And the short answer to that, and I think Chief Justice Roberts did it, New world, same old Constitution. And that's a way of saying that should have sent shivers down the spine of S.G. Sauer. The meaning is the meaning, and if the consequences change, we still have the same result. And I think he is one of the majority that will rule against the administration here.
So, Kermit, the 14th Amendment, for example, does not use the words mother or father, focuses on the child, where that child is born, right? While President Trump's executive order focuses on the parents, their legal status. But is the parents' legal status relevant to the 14th Amendment? Help us to understand the difference and how consequential it might be.
Well, the parent status is relevant to the 14th Amendment in a couple of ways because there are recognized exceptions. So if you're the child of a foreign diplomat, for instance, you're not fully subject to United States jurisdiction. You have some degree of diplomatic immunity. If you're born to an invading army in territory that army is controlling, you're not subject to the jurisdiction of the United States because we can't practically enforce our laws against you. So there were some very narrow exceptions which were well recognized at the time of ratification. But as Cecilia Wang said, that was understood to be a closed set. It's not the case that people thought if times and circumstances changed, you'd get a whole bunch of new exceptions, which is really what the administration was arguing for. And as Harry said, as Justice Roberts said, we've got the same Constitution. We might live in a different world, but the rule is the same unless it's changed by amendment.
So then, Kermit, even if birthright citizenship is affirmed, what happens to the children who are entitled to citizenship but have already been deported?
Well, you've deported U.S. citizens. And, I think there's no question that this government has done that. This government has done a lot of things that are pretty blatantly unlawful or unconstitutional. One of the really striking hallmarks of the Trump administration is that they just go ahead and do things, and they let the courts sort it out later. And in a lot of cases, the Supreme Court has let them go ahead and do that and inflict harm that just can't be undone. So I'm certainly optimistic that that's not going to happen in this case. But there are a lot of things this administration has done that we will never be able to fix.
Well, I want to go back to that because Claire McCaskill, when we were talking to her earlier, Harry kind of raised that question. There's a lot of things that a lot of people thought were done. Roe v. Wade, done, right? Yeah. Is that similar? Is this similar? Are people's concerns, given the recent history of the Supreme Court, justified?
I think they are, but in a different way, and I think Kermit is saying it very well. It's the unscrambling the eggs problem, and Trump has again and again kind of lunged ahead, and in supposedly a temporary fashion, the courts have permitted him to do it, but temporary has permanent consequences. For example, we're seeing that. Will he temporarily be able to go ahead with the construction of the East Wing? And then it's sort of there. So it's a whole nother problem. It's always harder to unwind. And it's happening it's a cross-cutting theme in the Trump administration because they do go ahead, not ask permission and wait to be sued.
Yeah. So, Harry, Let me play what the Justice, or the Solicitor General, John Sowers, responds to a question by Justice Alito about the humanitarian aspect of this issue.
On the humanitarian point, I would point out, as I said at the beginning, Justice Alito, that the United States rule of nearly unrestricted birthright citizenship is an outlier among modern nations. It's a very small minority of nations that have that rule. For example, every nation in Europe has a different rule. And the notion that they have a huge humanitarian crisis as a result of not having unrestricted birthright citizenship, I don't think is a strong argument.
My question is, because there was talk about the humanitarian aspects of this, and we have talked about what that would mean for mothers and children, but is this about legal questions, or do the humanitarian consequences play a role in this decision-making?
For the court, it should be about the legal questions, but remarkable, wasn't it, to hear Justice Alito saying, what about the humanitarian?
Yeah.
This is the bigger question that I was talking about. Who are we as a nation? He's right, we're outliers, but that's because the 14th Amendment made this grand statement that one's ability to be a citizen doesn't depend on who your parents are. That's a very American, grandly democratic proposition. And that's a big one, a part of our national identity. For the justices, it ought to be subject to the jurisdiction, et cetera. And I think that's what you will see more than these policy arguments.
Chuck, the New York Times did a deep dive into the immigration histories of these 9 Supreme Court justices, which, quote, span much of the American experience, from colonists who arrived before the nation's founding, to black people forced into slavery on Southern plantations, to immigrants who flocked to the United States from all across Europe and found jobs as laborers and factory workers. In each case, these newcomers paved the way for a descendant to reach the privileged pinnacle of the country's civic life. I know that justices in their confirmation hearings will typically say they put their personal opinions aside. We heard it a lot, right, when they were asked about the abortion question, that they are going to follow the law. But can they separate who they are, their lived experience, their family's lived experience, from what they decide?
Well, this always informs our judgment, Chris. I mean, they may try and put it aside. Perhaps it's appropriate for them to put it aside. By the way, we all come from that background. Very few of us were here originally, whatever that means. And we're all informed by the way we grew up, by the way our parents and grandparents grew up. So, I read the New York Times article. I thought it was interesting, but it didn't just describe 9 justices. It described all of us. It described all Americans. And as Harry and Kermit have said, I think there is a common understanding, at least a widely appreciated understanding of what the 14th Amendment means. Could the court do something else? Sure. That seems unlikely, based not just on the text of the 14th Amendment and not just on the text of the 1952 statute that echoed the words of that amendment, but also just sort of how we have grown as a nation, how we have come to understand these charter documents and the things that we aspire to, including this notion derived from English common law of birthright citizenship.